about what the fight between Mr. Depp and Ms. Heard was about that's reflected in this note?
I don't really recall. I remember a general sense of Ms. Heard being very upset that her phone was hacked because there was very sensitive information that was leaked from it. And I feel like she was having a difficult time calming after that. So what there was any verbal disagreements, I would assume it's in relation to that, but I just don't remember the specifics of what that disagreement was about.
It says here, the client states she feels fiance did not provide support to client. Did I read that right?
Yeah. Yes.
Okay. Is that consistent with your recollection?
I didn't recall that, but again, I would state that my notes are much more reliable than my current memory, and I think that probably speaks to your previous question.
Let's please go to the entries which from March 7th, 2015, which are on page with the base number 16952. Now, I think we looked at these entries earlier. Do you recall that?
Yes.
Okay. Now, with respect to the entry for March 7th, 2015, it says client notifies RN via text of increasing anxiety, reports emotional lability. Do you recall Ms. Heard reporting why she was feeling anxious at this time?
No, I don't recall the specific reason of why she is notifying me of that at this time.
So it says here that she notified you via text, right?
Right.
Directing your attention to the next note for March 8th, 2015. And I know you discussed this with Adam earlier, so I won't belabor this too much. But do you recall that at the time of this entry on March 8th, 2015, Ms. Heard was in Australia?
I would make that assumption based upon my note for March 8th. I state that client will be returning to Los Angeles, accompanied by house manager Ben. I'm paraphrasing there, but yes, I believe she was coming from Australia for this particular entry.
It says here RN plans to meet client upon arrival. Do you see that?
Oh, yes, I do.
And I think you testified to this earlier. You did see Ms. Heard the next day when she arrived back in Los Angeles. Is that correct?
That's correct. If you look at the entry for March 9th, I refer to meeting her and her friends. So yes, I would have met her in person that day.
Do you recall how long you spent with Ms. Heard that following day?
I don't recall. My note states that I met her for dinner at 2200, which military time would be 10 p.m. I don't recall how long I was with her. So I would assume a couple hours, but again, I'm just making an assumption.
Do you recall observing any injuries to Ms. Heard when you saw her on March 9th, 2015?
No, I don't recall. I don't make note of it, but I don't recall either.
If Ms. Heard had visible injuries, is that something that would have documented in your nursing notes?
I would assume so.
Do you recall Ms. Hurd seeking any medical treatment from you when you saw her on March 9th, 2015?
I don't recall.
If Ms. Hurd had sought medical treatment from you on that date, is that something you would have documented in your notes?
Perhaps if there were requests for medical treatment that differed from sort of day-to-day status, then yes, I might have put it in my notes if I hadn't discussed with Dr. Kipper, but I don't make any reference to it in this particular note.
Could we please pull up what should be in, I think I would have uploaded as document B. It bears the base numbers Pilati 0134. Is that 14? I think we covered this before, but just to confirm, is this your email up at the top that says erinboren@hotmail.com? I'm sorry, did you respond?
Yes.
Oh, great. Thank you. I'm sorry. I didn't hear that. Okay. I'd like to direct your attention down to this email from David Kipper on March 9th, 2015. That starts out, Erin, love you too much. Do you recognize this email?
I believe I produced this in reference to the subpoena.
Do you recall receiving this email?
I don't recall, but I do remember reviewing this. I don't think I reviewed it in preparation for today, but probably at the time of the document request. I think I probably reviewed this.
Directing your attention to the middle of the email, do you see where it says, I'm sure JD will let her know we are coming home. I want her to please not see him for a few days until we can get him organized with the hand surgeon and get his meds balanced. Do you see that?
Yes.
Okay. And JD refers to Mr. Depp in this instance?
Yes.
And the her is Ms. Hurd?
Yes.
Did you have an understanding at the time as to why Dr. Kipper didn't want Ms. Hurd to see Mr. Depp for a few days?
I don't recall exactly. This might have been in reference to Australia when they, meaning Mr. Depp and Ms. Hurd, were separated. I would have to check the dates on that.
Turning back to your notes where Ms. Hurd was returning from Australia on March 9, 2015, is that orient you?
Yes, thank you. Yeah, that would be the same time period.
Okay. And you alluded to an understanding that Dr. Kipper wanted Mr. Depp and Ms. Hurd separated.
Yes.
And what was your understanding as to why they should be separated?
I don't recall specifics. I wasn't present in Australia at that time. I just remember a general sense of a big argument happening and the treatment team deciding that they should not be around each other. So Ms. Heard returned to Los Angeles, and Mr. Depp stayed in Australia. For how long, I don't recall.
Next one here says, please use the excuse that Dr. Kipper insists that JD stay quiet without any distraction for the rest of the week while we get his medication organized and balanced. None of this will be accepted by her, but I will be very upset. You can tell her this. If there is any stress created by a visit, that's premature. Do you see that?
Yes.
Do you have any understanding as to why Dr. Kipper was directing you to provide this excuse to Ms. Heard?
Yeah, and just the general sense that there was a major argument in Australia, which I wasn't present for, and separating because of that.
Did you have any understanding as to why Dr. Kipper stated that none of this will be accepted by Ms. Heard?
I would be speculating on that, but you know, we used joking terminology.
Based on your experience treating Ms. Heard at this time in March of 2015, would you agree, or did you agree with Dr. Kipper that Ms. Heard would not accept not seeing Mr. Depp for a period of time?
I don't know specifically. As I think we talked about much earlier this morning, there was generally a sense of arguing, reconciling, and that sort of cycle happening frequently throughout their relationship.
If we could please go back to the nursing notes, which are Exhibit 2. Could we please go back to the entries from March 2015 that are on the page with the base number 16952? Now, we covered this earlier, but it says in your March 9, 2015 entry, it says client states she would like to discuss recent events between her and husband with RN in private tomorrow. Do you see that?
Oh, yes, I do.
Directing your attention to the entry for March 10th, 2015. It says RN met client at home at 1600. Does that refresh your recollection that you did meet with her the next day?
No, it doesn't refresh my recollection. However, I would refer to my nursing note.
Do you have any reason to doubt that these notes are accurate?
No.
Do you recall what Ms. Heard showed any injuries to you on that at that time?
No, I don't recall any injuries.
Okay. Can we go back to Exhibit 2, which is the nursing notes, and specifically the entry for March 25th, 2015. Just go back up to the top of this entry for March 25th, please. And I just want to ask you one more part of this. It says, states she is concerned about ability to trust fiance following argument on March 23rd, 2015. Do you have any recollection of Ms. Heard expressing concern about her ability to trust Mr. Depp?
I would say I have a generalized memory of there being, as I stated before, jealousy and anxiety issues, including mistrust within the relationship.
Do you recall Ms. Heard ever telling you that she thought Mr. Depp was cheating on her?
No, I don't recall that specifically. I just as I've said, have a general sense of remembering jealousy being an issue.
If we could, okay, I think, do you recall talking about visiting Ms. Heard and Mr. Depp for Thanksgiving earlier today?
Yes.
Does anything stand out in your mind as from that Thanksgiving dinner that you can recall?
Nothing really stands out other than it was, I sort of have a general sense of it being a really jovial, fun time together.
Do you recall how long you stayed at the dinner?
Not specifically, I would assume a few hours.
Could we please just quickly go to the note from November? This is in Exhibit 2, and then entry for November 26, 2015, which is on page 16954.
December.
Ms. Bellotti, directing your attention to the entry for November 26, 2015. You recall seeing this entry earlier today?
Yes.
And I believe you testified that this is the entry from the Thanksgiving dinner that you spent with Ms. Heard and Mr. Depp?
I believe it is.
Do you see in the middle where it says JD appeared calm and coherent?
I do.
Is that accurate to your recollection of that evening?
Again, I don't remember that specifically, but I just remember a general sense of it being a fun, happy evening.
So this is consistent with your recollection of that evening?
I would make that assumption.
And you have no reason to doubt the accuracy of your note, correct? Directing your attention to the December 17th, 2015 entry. Will you just take a minute and read this over and confirm whether strike that. Do you recall going and visiting Ms. Heard on December 17th, 2015?
I remember it in so much as my nursing notes regarding this night. I can't say that I recall much more than I have here, but I do remember visiting her.
It says here that the client had visible bright red blood appearing at center of lower lip. Do you see that?
Yes.
Did you, other than the blood on Ms. Heard's lip, do you recall seeing any other injuries to her on that date?
I don't recall other than what I state.
Do you recall examining Ms. Heard's lip at all?
I don't think I examined it other than a visual examination. I didn't physically examine her lip.
The note says here, client also stated her head is bruised and that she lost clumps of hair in altercation. RN briefly looked at client's scalp, but was unable to visualize hematomas client had described. Is that what you wrote in your note?
Yes.
If you had observed the bruises or hematomas that Ms. Hurd had described, would that have been reflected in your note?
Would assume, but again, I'm not trained in looking for those types of injuries, which is why my note continues that I encourage her to be seen by a professional that is trained to do so.
Can we drop down to the next page? And this is just the end portion of this note. It says here, RN reminds client to hydrate with oral fluids and to limit abstain from alcohol. Client was consuming red wine when with RN left, but assured RN she would consume in moderation. Is that what you wrote in your note?
It is, and I believe I miswrote there. Probably it should say client was consuming red wine when RN left, not with, just to clarify.
Why would you advise Ms. Hurd on this occasion to limit, or why did you advise Ms. Hurd to limit or abstain from alcohol on this occasion?
I don't recall why I would be speaking to limit or abstain from alcohol on this occasion.
To confirm, based on your nursing notes, you were aware that Ms. Hurd claimed to have been injured by Mr. Depp in December of 2015, right?
Correct.
And you went and actually saw her shortly after that alleged incident, correct?
Not that same day, but possibly the following day, I believe.
And you, on that occasion, you observed that she had a bloody lip, correct?
Correct.
And she told you that that was a result of the altercation with Mr. Depp, right?
Right.
If she had had any other injuries on that occasion, would you have recorded them in your nursing notes?
I made that assumption based upon my other notes that reference the blood on her lip.
Could we go back to Exhibit 2 in the nursing notes for April 21st, 2016? Which page number? Which is on page number 16957. Where it says, RN socialized with JD for 45 minutes. JD appeared coherent, oriented, and sociable, thought process logical and clear. Do you have any reason to doubt that that's accurate? That's an accurate description of Mr. Depp on that date?
Jessica, I apologize. Can you just use your cursor to help me see the note that you were just reading?
Sorry, I actually don't have control of it, but it's down towards the middle. It says RN socialized with JD at times 45 minutes. JD appeared coherent, oriented, and sociable.
Oh, yes, I see it. Thank you.
Thought process logical and clear. Yes. Okay.
Oh, I'm sorry. What was your question regarding that?
Do you have any reason to doubt that that's an accurate description of how Mr. Depp appeared to you on April 21st, 2016?
I have no reason to doubt it. I would stand by my notes.
You knew that Mr. Depp was being treated for substance abuse issues by Dr. Kipper and Nurse Debbie Lloyd, correct?
Yes.
if Mr. Depp had appeared intoxicated on this occasion, is that something that you would have documented?
If it had been outwardly visible for either client, I would have made reference to that.
If we could go back to the nursing notes, Exhibit 2, please. And if we could go down to the entry for May 11. Now, Ms. Lottie, we looked at this. You looked at this entry earlier today, correct?
Correct.
Directing your attention to just a couple lines down, it says, client discussed her birthday trip to Coachella Music Festival. Trip was April 22nd, 2016 through April 24th, 2016. Client admits to illicit drug use during the trip and states she ingested mushrooms and MDMA simultaneously while also consuming alcohol, and states she vomited and was, quote, high for at least 24 hours straight, end quote. Do you see that?
Yes, I do see that.
Did I read that correctly?
Yes, you did.
Do you recall, well, first of all, do you recall Ms. Heard relaying this to you?
I don't recall these specifics that I state here in the note, but I remember sort of a conversation talking about the trip after they had returned.
And this starts out, client admits to illicit drug use. So am I correct that this is, based on these notes, this is something Ms. Heard reported to you directly?
Again, I don't remember these specifics. However, my usage of client admits refers to the client reporting something to me.
Had Ms. Heard ever admitted to illicit drug use to you before this time?
I believe in reference to my nursing notes from when I first met her, she alluded to previous substance use.
It says here, RN reminded client that illicit drug use will not be tolerated by medical staff and that any medications or drugs that are not prescribed can interfere and cause adverse effects with her prescribed medication. Client laughed and also reported using illicit drugs, mushrooms and MDMA on May 9th, 2016, at home with a high-profile male acquaintance. Did I read that correctly?
Yes, you did.
Do you recall Ms. Heard laughing in response to your reminder about illicit drug use?
No, I don't recall that.
In your time caring for Ms. Heard, did you ever see Mr. Depp physically abuse her?
No.
Did you ever see Ms. Heard physically abuse Mr. Depp? Did you ever see Ms. Heard throw anything at Mr. Depp in the time that you cared for her?
No, I did not witness that.
In the time that you treated her, did you ever see Ms. Heard lose her temper?
As we talked about previously, the one incident that I can remember is in London, 2014. Yes, 2014. In regards to the phone being hacked and sensitive material being leaked.
Did you ever feel that Ms. Heard was hostile towards you at any time during your treatment of her?
No.
Did you ever feel like she was ignoring attempts by you to contact her?
Yes, I have a general memory of not often, I should, excuse me, I misspoke. of that happening on more than one occasion where I would reach out and not get a response. I remember feeling frustrated by that.
When had you treated domestic violence victims prior to this time?
The time that I worked with them was in nursing school. I don't want to say the specific place for confidentiality reasons, but it was for domestic violence victims. Sort of a safe house.
Ms. Wadi, do you remember when you were treating Miss Heard that at some point she had a cyst on her eyelid?
Yes, that sounds familiar.
Okay. And do you remember that you had a procedure to have that cyst removed?
Yes.
And was that a surgical procedure to recollection?
From what I recall, that was handled at an outpatient surgical center. Other than that, I don't know the details of that specific process.
Do you recall whether Miss Heard had any marks around her eye after having that procedure?
I don't recall. I remember a topical ointment being applied, but I don't recall if there were marks on her eye or not.
At this point, the questioning switches back to counsel for Ms. Heard. All right, thank you.
Do you see Pilates 93?
Yes.
Okay. And this is another picture of Amber from May 21st, 2016.
Correct. This is a picture of Ms. Heard.
And Amber sent you this text on May 21st, 2016.
I believe so, based on the timestamp.
And the same for this picture on the next page. Amber sent you this picture of her.
Correct.
And the same for this page, the next page. Amber sent you this picture of her on May 21st.
Yes.
When you saw Amber on December 17th, 2015, and you spoke about that, how long were you with her? Do you recall?
Don't recall. I would assume, based on the fact that I stopped by briefly, maybe an hour or two.
Okay. Did you go inside her house, or were you outside the door?
From what I recall, I was inside
Okay.
the penthouse, yes.
By the way, when you saw Amber on December 17th, was she wearing makeup or not? Do you recall?
I don't recall. Yeah, I don't recall.
All right, thank you. Before we get to the next witness, could I have counsel approach on the plaintiff's 46? All right, so plaintiff's 46 is in evidence. Your next witness? Yes,
Yes,
Mr.
Your
Dixon?
Honor. Plaintiff calls Michael Spindler.
All right, Mr. Spindler? Yes.
Good morning, sir.
Good morning.
Would you state your name for the record?
Michael Spindler.
Where do you live?
I live in the Los Angeles, California area.
What's your occupation?
I'm a forensic accountant.
What do you mean by forensic accountant?
Well, a forensic accountant does accounting work that is a bit more investigative in nature. So it's essentially taking a look at business records and accounting records in connection with some form of business issue.
How long have you worked in that field?
I've been a forensic accountant full-time since 1990.
What did you do before that?
Before that, I spent about 10 years doing auditing of financial statements.
Can you describe your educational background?
Yes, I graduated in 1981 from the State University of New York at Albany with a Bachelor of Science degree in accounting and a minor in economics.
Are you currently employed?
I am.
Who's your employer?
B. Riley Advisory Services.
What's B. Riley Advisory Services?
It's a national forensic accounting boutique firm that does forensic accounting, business valuations and appraisals, and bankruptcy and restructuring work.
How long have you been employed at B. Riley?
Since January of 2015.
What did you do for work prior to B. Riley?
Well, it's a long career, so I'll give you the highlights. I spent about 30 years with national accounting firms as partner at 2 different firms, and also was involved with a couple of forensic accounting boutique firms.
Okay. Do you hold any certifications?
I do.
What are they?
I'm a certified public accountant with licenses from 6 states: New York, California, Arizona, Nevada, Utah, and Hawaii. I'm also certified in financial forensics. I'm a certified fraud examiner. I'm accredited in business valuation and a certified anti-money laundering specialist.
Do you participate in any professional organizations?
I do.
What are those?
Well, I've had leadership positions in a couple of them. I'll mention the Association of Certified Fraud Examiners. I was the president of the Los Angeles chapter, and I'm currently on their board. I've been actively involved with the California Society of CPAs. I was the president of the Los Angeles chapter. It had 11,000 members at the time. Was also on Cal CPA Council, which is kind of their board of directors, and also member of the board of trustees of the Cal CPA Education Foundation.
Have you testified as an expert before?
I have.
Approximately how many times?
About 100 times, roughly. About half of that in trials and arbitrations.
What's your typical role in those cases?
Typically, it can take a number of forms, but commonly I will testify with respect to damages.
Have you done any film industry work?
Yes, I have.
What was that?
I've done work involving all the major film studios. I've also done work on behalf of writers, directors, producers, actors, studio executives.
Your Honor, I'd like to proffer Mr. Spindler as an expert in forensic accounting.
All right, any objection?
No objection.
All right, so moved. Thank you.
What work did you do in this case?
Well, in this case, I was asked to take a look at issues with respect to lost earnings for Mr. Depp.
What in particular did you do?
I looked at accounting records that were produced by Mr. Depp's accounting firm, Ed White & Company. I looked at trial exhibits. I looked at deposition testimony. I looked at some trial testimony. And I've looked at various other documents and exhibits in connection with the case.
What specific period did you analyze with respect to lost earnings?
I looked at the period following the publication of the op-ed. So I looked at the period from December 18th, 2018 through October 31st, 2020.
What materials did you review?
I looked at the accounting records that have been produced by Mr. Depp's accountants.
Any other materials?
Various deposition transcripts, trial testimony, contracts, etc.
What conclusions did you draw from your review?
I concluded that Mr. Depp suffered lost earnings of approximately $40 million.
How did you reach that conclusion?
Well, there are really two main components to that. The first relates to the loss of the role of Captain Jack Sparrow in the Pirates 6 film. So the loss related to the loss of that role in that franchise picture was $22.5 million based on testimony provided by Mr. Jack Wiggum. In addition, we looked at, yes?
Did you do anything else with respect to Pirates 6?
Well, we also calculated the net earnings that Mr. Depp would have received from that.
Okay. And what did you base your analysis of Pirates 6 on?
Based on the testimony of Mr. Jack Wiggum.
Okay. What else did you do with respect to the lost earning analysis that you did?
Well, the other main component to this is taking a look at all the other roles, the non-franchise films. So those films, studio films, independent films, and endorsements that Mr. Depp realizes and enjoys. So in connection with that, we looked at his bookings for the year 2017. And by bookings, I mean instances where Mr. Depp is hired for a project. And he receives that first money related to that project in 2017. So, in other words, you've got a deal, and cash has showed up, so it's real. So we looked at his 2017 bookings, and we calculated for that year, for that period, his bookings were about $17.5 million. The main components of that, Mr. Wiggum testified to. We then looked at the period of time following the op-ed of December 18th, 2018 through October 31st, 2020. So if annual earnings was $17.5 million, in what is known as a typical year, a reasonable base year, at that rate, what would we have expected Mr. Depp to have earned from that period of October 18th, 2018 through October 31st, 2020? And we then compared that to his bookings, his actual bookings for that period of time.
Why did you use 2017 as a typical base year?
Well, a couple of reasons. First of all, Mr. Wiggum testified that that was a typical year for Mr. Depp. And it's also the most recent clean year that was experienced. In 2018, you had the publication of the op-ed. That didn't happen in 2017.
Okay. Did you prepare anything to assist the jury with respect to the analysis that you performed?
We did prepare a chart, yes.
Okay. Your Honor, may I approach?
All right. Yes, sir. Good.
Thank you.
Your Honor, I think this is Plaintiff Exhibit 1240. I'm not going to move it into evidence. I'm simply just going to use it, with your permission, to publish it to the jury so that the witness can explain it.
Any objection to demonstrative 1240? All right, demonstrative. Well, do you have electronic copy of it? Okay, that's fine.
We do. Okay. Who did this chart?
I, in combination with people working under my direction from my firm.
All right. Can you explain to the jury what you've done here?
Sure, I'd be happy to. So, as we discussed previously, Mr. Depp lost the role in Pirates 6, and the effect of that was lost earnings of $22.5 million based on Mr. Wiggum's testimony. And then what we've shown here is the 10% agent commission.
So why did you deduct 10%?
Because that's the rate for Mr. Depp's agent. That's what his agent receives out of Mr. Depp's earnings. in connection with setting up a project for Mr. Depp. So we deduct that 10%, which comes to $2,250,000, just 10% of $22.5 million. And the net effect of that, the amount that Mr. Depp would have received after deducting that fee, would have been $20,250,000. And that's the first component of this.
All right. What did you do in terms of the analysis of lost bookings for non-franchise films?
Okay, so that's the next section of the chart. And as I mentioned before, his 2017 bookings were about $17.5 million. So that rate of earnings over the period from mid-December through the end of October 2020, or mid-December 2018 through the end of October 2020, would come to about $32.8, $32.9 million. We then compared that to actual bookings during that period of time, of mid-December 2018 through the end of October 2020. That amount was $10,586,000. We deducted those bookings, the actual amounts, from what we would have expected to arrive at his lost bookings for non-franchise activity, and that comes to about $22.3 million. And once again, we've deducted the 10% agent's commission. So the net effect, the lost earnings to Mr. Depp after that agent's fee for non-pirate films comes to about $20 million.
What does the figure at the bottom corner of the chart, the $40,318 and $40,318,237, what does that represent?
Well, that's your grand total. That's the sum of those two components for total lost earnings of $40.3 million.
No further questions, Sean.
All right, cross-examination.
Thank you, Your Honor. Good morning, Mr. Spindler.
Good morning.
So this lawsuit isn't the first time you've worked with Johnny Depp, is it?
It is not.
You've worked with him in a lawsuit that he had in the past with his old law firm, correct?
Yes, just a little bit of work, yes.
And so in this second go-round as a paid expert for Mr. Depp, you're making $550 an hour is what he's paying you? Is that right?
That's the amount that my firm bills. I do not receive that.
Now, the subject matter of your opinion testimony in this case is the economic damages that Mr. Depp has allegedly suffered as a result of Ms. Heard's December 8, 2018 op-ed, correct?
Correct, yes.
And this is the first case in which you've testified as an expert relating to economic damages claimed by an actor, correct?
First time I've testified to, but I've done that work before.
And you understand that this case is about only whether Ms. Heard's December 18th, 2018 op-ed constitutes defamation of Mr. Depp, correct?
That's my understanding.
And you understand that this case isn't about anything else Ms. Heard has ever said or done, correct?
I believe that's correct.
And to be clear, you are testifying only as to alleged damages, right?
Correct.
So you are not offering any opinion or any testimony on whether those specific damages that you just discussed were caused by the op-ed, correct?
That's correct.
And you're assuming for the purposes of your report that the damages that you're testifying about were caused by Amber's op-ed, correct?
Yes.
So you're therefore not looking into whether anything else that's happened with Mr. Depp's life or career could have caused him economic damages, correct?
I believe that's generally correct, yes.
So you're not looking at whether the article published in the UK in June 2018 calling Mr. Depp a wife beater caused him the damages, correct?
Correct.
You're not looking at whether the lawsuit that he brought in the UK against the publisher of that article caused him those damages, right?
Correct.
You're not looking at any of the evidence that came out in that lawsuit about alleged instances of abuse against Amber, correct?
Correct.
You're not looking at any of the evidence that came out in that lawsuit about alleged instances of abuse against Amber, correct? You're not looking at any of the evidence that came out in that lawsuit about alleged instances of abuse against Amber, correct? You're not looking at whether the consequences of Mr. Depp's drug and alcohol use have caused him the damages you're discussing, correct?
Correct.
You're not looking at whether the worsening performance at the box office of Mr. Depp's movies over time has caused him the damages that you're testifying about, correct?
Correct. And I'm not acknowledging any of this being accurate. I'm just saying that that wasn't part of my calculations.
Sure, I understand. I just want to make clear what you didn't look at, what you're not opining on. And so to round that out, you're not considering even the impact of Amber obtaining a restraining order in May 2016 and whether that may have caused some damages. That's not part of your opinion, correct?
Well, since we were taking a look at lost bookings using 2017 as a base year, any activity that preceded that would have been baked into those calculations that way.
And we'll get to those calculations in a minute because I'm going to put up the chart that you put in your expert report. But first I want to talk about Pirate 6 because that's basically the two components of your damages is Pirate 6 and then this non-franchise lost bookings, right?
Correct.
So for Pirate 6 specifically, you assume that he would have made $22.5 million on Pirate 6, right?
Correct.
And you took Jack Wiggum's word for it in making that assumption, correct?
I based it on his testimony, yes.
Now, you never saw a contract that Mr. Depp had for Pirate 6, correct?
Correct.
Because no contract exists, to your knowledge, correct?
So far as I know, I've not seen one.
And you didn't take into consideration Jack Wiggum's testimony that Disney was non-committal about Mr. Depp being in Pirate 6 even before the op-ed, correct?
Correct.
And you didn't take into consideration the press articles that came out prior to the op-ed that suggested that Disney had made a decision not to cast Mr. Depp in Pirate 6, correct?
Correct.
And you have no idea whether Pirate 6 will ever be made, right?
I wouldn't know that.
And you have no idea if Disney has decided one way or the other whether Mr. Depp would be in it or whether they'd offer him a role in it if it is ever made, correct?
Well, my understanding is that they made a public statement that he would not.
Okay. And you have, if Disney decided that he wouldn't be in it, you have no idea when they decided that, correct?
I know that there was a public announcement subsequent to the publication of the op-ed.
What public announcement are you talking about?
I believe there was an interview of Mr. Bailey that was published several days after.
Oh, okay. Well, that interview of Mr. Bailey didn't say that he wasn't going to be in it. In fact, have you looked at the article that the jury saw the headline for yesterday, dated November 5th, 2020, about Mr. Depp potentially not being in Pirate 6? Have you looked at that article? I assume not.
No.
Okay. And you didn't take into account Mr. Depp's statement that he wouldn't do Pirate 6 for $300 million and a million alpacas, correct?
That sounded like hyperbole to me. I didn't take that very seriously. It sounded like somebody who was a bit hurt or in pain as a result of the loss of the role.
So if Mr. Depp didn't lose a role in Pirate 6 because of the op-ed, but he lost it for other reasons, then your damages opinion relating to Pirate 6 would drop to $0, correct?
I believe that's correct. If it's not lost for that reason, if it's lost for some other independent reason, then I think that would need to be considered.
Okay, thank you. Now let's shift gears and talk about the non-franchise earnings for a moment. You claim this number is about $21 million, right? Roughly.
20.
We'll pull it up. Well, actually, we'll look at the chart here. $20 million, about $20 million after agent fees.
Correct.
Okay. And to reach that number, you looked at what his historical earnings records showed, right?
Correct.
And you got that information from Ed White's office?
Yes.
And you assumed that the information you got from Ed White's office was accurate, right?
I did, yes.
Can we please pull up the chart that's in his expert report? Your Honor, this is, or Mr. Spindler, I'd like you to take a look at this and confirm for the court that this is the chart that's in your expert report, if you would.
It appears to be, yes.
Your Honor, I'd ask for permission to publish this just as a demonstrative.
Any
No
objection?
objection.
All right.
So, Mr. Spindler, this chart shows Mr. Depp's earnings by year based on the information that you received from Ed White, correct?
Correct.
From 2009 to 2020?
Yes.
And it shows that from about 2009 to 2019, and I didn't add these up visually, but from your report, you say that Mr. Depp made about $459 million. Correct?
Correct.
Now, the two highest earning years in this time period were 2010 and 2011, right?
Yes.
You see that? You made about $70 million in 2010.
I do. Yes.
And then the third highest year was 2014, right?
Yes.
Shade under 60 million. And you'd agree that from the period of 2010 to 2020, his annual income on average was decreasing.
Yes, but you have to take a look at the components of this.
Right.
And
in
as
2000, I was just wanted to get your agreement that from 2010 to 2020, his annual income was decreasing. Now, in 2020, he earned more than he did in 2016, correct?
On an overall basis, yes.
And in 2020, he earned more than he did in 2018, correct?
Yes, just
After the
based on
op-ed.
earnings.
And in 2018 and 2019, he earned an almost identical amount, correct?
Yes,
And
just based on
2019 and
earnings.
2020 were both after the publication date of the op-ed, correct?
Yes.
Okay, now I want to talk about some of these non-franchise earnings because when I looked at your chart that was displayed to the jury, I didn't see anything specific listed. So can you just confirm for me that you can't name a single lost business opportunity other than Pirate 6 that Mr. Depp lost as a result of the op-ed?
That's correct. That's
And
not the
you can't
nature of this
identify
calculation.
a single television, if you could just answer my questions yes or no as best you can, please. You can't identify a single television project that Mr. Depp allegedly lost out on as a result of the op-ed, correct?
Correct. That's not the
And
nature
you
of this.
can't identify a single advertising campaign or marketing opportunity that Mr. Depp lost out on as a result of the op-ed, correct?
Right. These are the calls.
And
that
so
we did
it's
not
fair to
receive.
say that for the lost opportunities that you can't name, you're assuming, as with Pirate 6, that those opportunities were lost because of the op-ed, correct?
Correct.
Now, you mentioned something interesting in your direct and in your report. You say that you used 2017 as the base year to calculate what you claim Mr. Depp's should have earned in 2019 and 20, correct?
Correct.
And let's take a look at this because 2017 he made that much, correct? About 45 million or so?
Yes.
But in 2016 he made just a shade over 20, correct?
Correct.
2018 he made a shade under 20, right?
Yes.
Same with 2019, right?
Correct.
And then 2020, he actually made more than he had in the prior 2 years or in 2016 and made about, 23 million or so? Is that right?
Right. But as I indicated, this is
So-
just based on earnings. You need to get behind.
Right. So you said, there were a couple interesting things you said. You said that the most recent, that 2017, I want to explore why you relied on that. Now, first of all, you said that you relied on Jack Wigham's testimony that 2017 was a reasonable year to use, correct?
Correct.
Despite the fact that 2017, he made more than twice as much as he's made in any year over the last 5 years, correct?
Yes,
And you
but
say
when you
that
take a
this
look
is
at
the most
their,
recent-
if I can
No.
finish this
you answered
thought.
my question. No, well, I want to get to your thoughts because you said that one of the reasons you used 2017 was because it was you said, I wrote it down, the most recent clean year, right?
Correct.
And then I think you explained, you said because the op-ed was written in 2018, right?
Correct.
But the op-ed wasn't written until December 18th, 2018, correct?
Yes.
So if 2017 was clean, then the first 352 days of 2018 were also clean, weren't they, sir?
If I may explain, Mr. Wiggum testified that for the first half of 2018, Mr. Depp chose to take some vacation time. Also, he chose to go touring in the summer with his band, and then he did a film towards the end of 2018. With the publication of the op-ed in December of 2018, that would have impacted the prospects for that film that was done in 2018. So he chose to do just the one film in 2018. And then the impact of the op-ed on that film would have meant that it was not a clean period. You could not have looked at that film to get a good sense of what his earnings should have been because he didn't have the chance to earn box office bonuses or profit participations. So that's why 2017 is a much, much better year to use than 2018.
Well, let's break that down. I think let's break that down a little bit. You said that 2017 was a much cleaner year, but isn't it also true that there were other reasons why 2018 wasn't clean? For example, the April 2018 article by Dan Wooten calling Mr. Depp a wife beater, correct?
That did occur that year, yes.
The June 2018 lawsuit that Mr. Depp filed in the UK against the Sun for calling him a wife beater, correct?
Yes.
And how about the October articles reporting that Disney had decided to move on from Mr. Depp and not cast him in Pirates 6, correct?
I'm sorry, what effect would that have had?
Well, it came before the op-ed, so it's another reason why 2018 isn't a clean year in your mind, correct? An article 2 months before the op-ed, an article 2 months before the op-ed saying that Disney had decided not to cast Mr. Depp, that would also keep 2018 from being what you would call a clean year, correct?
I've described the reasons why I believe 2018 was not a clean year.
Okay. Now, you're aware, as we talked about, that Amber's op-ed wasn't published till December 18th, 2018, correct?
Correct.
So Mr. Depp could not have lost out on any opportunities as a result of the op-ed prior to December 18th, 2018, correct?
Correct.
And he couldn't have lost out on any opportunities in 2017 as a result of the op-ed. Fair?
Fair.
And he couldn't have lost out on any opportunities in 2016 as a result of the op-ed, correct?
Correct.
And so in calculating your damages, you didn't use 2016, you didn't use 2018, but you chose to use 2017, correct?
Yes,
and
for very
Mr.
good
Depp
reasons.
still made more in 2020 than he did in both 2016 and 2018 before the op-ed was published, correct?
Correct, and that's
Nothing
just
further.
based
Thank
on
you, sir.
earnings.
All right, redirect.
Yeah, thanks, Don. You explained 2018. Why didn't she use 2016?
Well, first of all, 2017 was a more recent year. 2017 was a year in which Mr. Wiggum indicated that that was a typical year for Mr. Depp. He had a studio film, he had a independent film, he had an endorsement deal. 2016 is further back in time. As I understand it, his earnings capacity for that year would have been just about the same or even higher than 2017, because there was an endorsement deal that Mr. Depp passed on that would have been worth a lot of money, according to Ms. Jacobs. So 2017 made the most sense.
Why did you ultimately use the method that you did to determine the lost earnings?
Because it just makes sense. It's the correct approach to take. You're taking a look at what Mr. Depp would have been expected to earn in a typical year, and then you're comparing that to the period of time where you're analyzing following the op-ed from December of 2018 through October of 2020. So you're taking a look at what you would have expected him to earn. It's very simple compared to what he actually did earn.
No further questions, Your Honor.
All right, thank you. Is this witness subject to recall? All right. Sir, since you're subject to recall, do not discuss your testimony with anybody, but since you are giving expert testimony, you're free to stay into the courtroom, okay, sir? Thank you. You have a good day.
Thank you very much.
All right,
Thank you, everyone.
watch your step there. All right. So
Plaintiff rests his case in
All right, plaintiff rests. All right, ladies and gentlemen, we're going to go ahead and take our morning recess. It may be a little longer because I have a few issues to take up with the attorneys, but then we'll proceed after that, okay? So please do not talk about the case and do not do any outside research, okay? Thank you.
You didn't think okay.
All right. Why don't we go ahead and take our recess till 11:45, and then I'll come back and entertain the motions at that time, okay? All right, thank you.
But at the same time, granting a motion to strike is appropriate when the plaintiff, as is the case here, has failed to present evidence sufficient to create an issue of fact on his claims. And in addition, the court may not draw inferences from the evidence that defy logic and common sense. That's the Austin versus Shoney's case, 254 Virginia 134. So the issue here, Your Honor, is a couple-fold, and I'll take the statements, two of them in one category and one of them in the other category. But I think we're all clear that the sole issue here is whether Amber Heard can be held liable to Mr. Depp for defamation arising from the 2018 op-ed and the 2018 op-ed alone. And to establish that, Mr. Depp has to prove the following elements. He has to prove that the publication of the op-ed and that it was written by Ms. Heard. He has to prove that the statements in the op-ed were both false and defamatory. So falsity, and that they contained a sufficient defamatory sting, and he has to show that the statements were made with the requisite intent. In this case, actual malice on the part of Amber Heard. I'll save that argument till the end, Your Honor, and I'll focus on the first two at this point. And because it seems like plaintiff is proceeding under a theory of defamation by implication, under the Pendleton case, 290 Virginia 162, plaintiff bears the burden of proving that the statements at issue were designed and intended by Ms. Heard to imply a defamatory meaning. Designed and intended to imply a defamatory meaning. So, and to satisfy those first two elements, publication and falsity and defamation or defamatory nature of the statements, Mr. Depp bears the burden of proving that by a preponderance of the evidence. And to satisfy the requisite intent and show that Ms. Heard acted with actual malice, he has a heightened standard of proof that he must prove by clear and convincing evidence that Ms. Heard acted with that malice. So just want to talk about the two statements on domestic abuse in the op-ed. And Your Honor's well aware of the ample Virginia case law talking about how you have to view the op-ed as a whole. You have to view words in context. So these are the statements that read, then 2 years ago, I became a public figure representing domestic abuse. And then the other statement that says, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. Now, those statements are entirely opinion, except for, according to Mr. Depp, the discussion of domestic abuse. So the statement, I became a public figure representing domestic abuse, and the statement in the second sentence that Mr. Depp was a man accused of abuse. The rest of those are inactionable opinion statements. Now, the evidence adduced thus far, Your Honor, shows that Mr. Depp can't sustain a claim on these for two reasons. First of all, the statements are true on their face. I don't think that there's any dispute about that, and that's been the subject of some testimony in this case. 2 years before she wrote the op-ed, Ms. Heard did, in fact, become a public figure representing domestic abuse when she obtained a domestic violence restraining order against Mr. Depp, and Mr. Depp was indeed accused of abuse. Those are facts that are true. Now, to the extent that Mr. Depp will argue that he's proceeding on a defamation by implication claim, again, the court should grant the motion to strike because the undisputed evidence is that he did, in fact, abuse Amber. Now, there's a dispute in this case. There's ample evidence that he physically abused Amber, but we acknowledge that there's a dispute in this case on that. But what there isn't a dispute in this case is non-physical abuse. Both Mr. Depp and his expert Shannon Curry have testified that abuse may come in many forms. It may be physical, certainly, but it may also be verbal, may be emotional, may be psychological. You'll recall Mr. Depp even kind of setting the baseline for what abuse was when he talked about the non-physical abuse that he allegedly suffered at the hands of his mother. He said it was worse than the beatings. And the example he gave was that his mom used to call him One Eye as an example because he had a lazy eye, I guess, as a child. That was something that Mr. Depp himself said was abuse, his mom calling him One Eye. So we setting aside the evidence of physical abuse in this case, which is already overwhelming, Mr. Depp's claims relating to these two statements should be stricken because of the ample and undisputed evidence in the record of non-physical abuse by Mr. Depp toward Ms. Heard. There's evidence in the record of recordings, messages, including messages written in blood, with his finger, blood and paint, vile names, shouting, menacing and threatening statements. There's the video, the kitchen video in Sweetser. There's the audio of him calling Miss Heard, like I say, numerous vile names. There's the audio of him asking her to cut him, and whether she wanted to be cut. So there's plenty of evidence out of the words or out of the mouth of the plaintiff in this case that constitutes non-physical abuse of Miss Heard. Again, under the standards set forth by his expert and the plaintiff himself. Those are far worse than his mother calling him one-eye when he was a child. In addition to that, Your Honor, there's Travis McGivern's testimony from yesterday in which he testified that at a minimum on the night of March 23rd, 2015, both parties were being verbally abusive to each other. Mr. McGivern also testified about Mr. Depp, quote, rearranging her closet, throwing racks of clothing down onto the floor and throwing at least one rack down the stairs. Now, in California, property damage alone can be a basis for getting a temporary restraining order under California law. So further evidence of non-physical abuse or non-physical toward Miss Heard. You saw the cupboards in the Sweetser kitchen video. And then Dr. Laurel Anderson, Your Honor, testified that she believed that the parties engaged in mutual abuse and that at least some of the time that was initiated by Mr. Depp. This is all evidence we haven't gotten to put on our case yet. And to the extent that this case proceeds, and that will start now, but this is all evidence that has come in while plaintiff controls the playing field of what evidence has come in, and he can't overcome that. In this case, Your Honor, if Mr. Depp abused Miss Heard physically, verbally, emotionally, or psychologically even one time, then she wins on those claims. Then she wins. It's that simple. And the evidence is overwhelming and undisputed in the ways that I've just described that he did. So for that reason, Your Honor, those claims should be stricken. And I'll just cite the Union of Needle Trades versus Jones case. This is 268 Virginia 512 that states, if the plaintiff does not establish the falsity of the statement by a preponderance of the evidence in his case in chief, he has not met his threshold burden, and the trial court should strike the evidence and grant summary judgment to the defendant. That's exactly what should happen here. Now I'll move on to the second issue, which is the headline containing the phrase sexual violence. That should be stricken for a couple reasons. First, Your Honor, the evidence has established that Ms. Heard didn't write the headline. Mr. Doherty from the ACLU, that's the only evidence that's come in this case thus far. Plaintiffs control the evidence.
Well, I understand, but there's also a stipulation that Ms. Heard would not be called in the plaintiff's case because they would then use her testimony for part of their case. In your case, right?
That's correct, Your Honor.
Yeah, I agree. And that goes to a different issue that I'm not arguing. I'm not arguing that the court should strike because they haven't put Ms. Heard on to testify about the headline.
But I assume part of that would be that they would, I guess they intend to get from Ms. Heard is that she either wrote it or republished it.
Yeah, what happened the next day is Ms. Heard posted it on her Instagram account and said, look what I published yesterday in the Washington Post. So she adopted the title, and her name was on the article which contained the title.
And Mr. Ronborn, the only reason I'm sorry to interrupt you, only because I know that was a stipulation, so it's hard for me to say that that's all the evidence for motion to strike if there's a stipulation that they're still going to get more evidence in on that particular issue.
I think, and I'm happy to hand the court the transcript of the April 8th hearing, because one of the things that we're not arguing today is that because they haven't put in evidence of I think it was a tweet, but Mr. Chu says it was Instagram, I don't know, whatever it was, that because there was...
It was a tweet adopting the op-ed she published the day before in the Washington Post.
Okay.
All right. So what I'm not arguing today is that because they haven't gotten that tweet into evidence or had Ms. Heard say that she tweeted that we're entitled to summary judgment at this point. I'm not arguing that, but that's all that we discussed on April 8th, and I'm happy to hand the transcript up, Your Honor. And we actually it wasn't a stipulation, it was simply an agreement that they didn't need to call her in their case in chief to make that point. And then Ms. Bredehoft said, we'd have to agree on the language of any stipulation, and they haven't proposed anything to us and haven't gotten back to us. So I think that's only relevant. We're not basing our request for motion to strike here on Ms. Heard not having testified to sending that tweet.
But you're saying for the motion to strike, the only evidence before the court is that the Washington Post wrote that title.
Correct. And that's very different from what happened the next day. The stipulation didn't go toward who wrote the title. That was never part of anything, and it's undisputed. And Ms. Heard will testify that she didn't write the title.
Well, I understand that, but I think
it's not undisputed, Your Honor. I apologize for interrupting.
Okay. But I think the issue is that whether it was republication.
Well, and I'll get to that next.
Right, I know, but the problem is, how do I do a motion to strike when that evidence isn't before me yet?
Well, the republication isn't. So the evidence that's before you is that the Washington Post wrote the headline, or that Ms. Heard didn't, and that's the only evidence, and that's not going to change. The tweet, which was the only subject of the discussion of the pretrial conference, where there was no stipulation, it was just an agreement that we're not going to base a motion to strike on them not introducing evidence of the tweet. That was what it was. I'm happy to hand the transcript up if Your Honor would like to see that. But that isn't actionable because under the Lakova versus Halper case, 995 F3rd 134, retweeting a link doesn't constitute republication. Now that case dealt with
it does if you add something to it, but I just don't know the evidence.
Your Honor, very quickly, it's a judicial admission. They admitted in Ms. Heard's answer, she admitted to the tweet. So that establishes that she adopted the op-ed in its entirety, and it was discussed. We talked about judicial admissions. One was the op-ed itself. The second, and this is reflected
Your
in
Honor,
the
if I could finish my argument, I mean, I would appreciate.
I can't wait to oppose this.
That's fine. Go ahead. Go ahead.
So, and again, we can look at the transcript.
You understand my concern.
I do understand your concern, and I guess what I'm saying is that there's two levels. One is there's no dispute, and there's not going to be a dispute that she did not write the headline. So then you look at is the tweet actionable? And the argument here is that as a matter of law, retweeting something isn't actionable. And so, as under the Lakova case, 995 F3rd 134, in that case dealt with hyperlinks and how those aren't actionable. But to be very clear, nothing that was discussed on April 8th, nothing that was discussed at that pretrial conference was in any way relating to any stipulation about who wrote the headline. It was simply that they need not call Ms. Heard in their case in chief to get her to say that she sent a certain tweet. And that tweet's not in evidence yet, but I assume that they'll try to put it in evidence at some point. But the tweet doesn't need to be in evidence for you to strike this claim on that basis. So even assuming that the headline implied certain conduct by Mr. Depp, again, Mr. Depp can't meet his burden of proof on this. Third, Your Honor, he can't prove that Ms. Heard acted with actual malice. Mr. Depp hasn't introduced evidence sufficient to permit him to meet this. Now, again, this is a heightened burden of proof. He has to show actual malice by clear and convincing evidence. And as the Bose Corporation case from the U.S. Supreme Court, it talks about the role of judges as gatekeepers of the Constitution, of the First Amendment, and the role of barring entry of a judgment that's not supported by clear and convincing proof. Now, that case was about appellate review of First Amendment issues, but the same holds true for Your Honor here. Here, Mr. Depp hasn't introduced any evidence, and there can't be a reasonable inference drawn that would permit a jury to find that he's proven by clear and convincing evidence that Ms. Heard wrote the words with actual malice. And again, we go back to the testimony of Mr. Doherty, which was their witness. They put him in, and Mr. Doherty, the only evidence relating to intent or anything relating to this op-ed, which was, again, maybe Mr. Chu will try to say that we stipulated to Ms. Heard's intent on April 8th, which of course we didn't. But the only evidence that has been presented in this case, Your Honor, by Mr. Doherty was that the op-ed wasn't Ms. Heard's idea, that the ACLU asked her to write the op-ed, and indeed that they even wrote the first draft, and then that Ms. Heard vetted the finished article with her lawyers and with lawyers from the ACLU to make sure that it wasn't problematic. That is the only evidence in the record. And on that evidence, there cannot be a conclusion that Ms. Heard acted with the actual malice that's necessary, particularly when you consider the heightened burden of proof. So reviewing the op-ed as a whole, with the court acting in its appropriate function as a gatekeeper of the First Amendment, we ask that the court strike plaintiff's evidence and award summary judgment to Ms. Heard, either in whole or in part. Thank you.
All right, thank you. Yes, sir.
Good morning, Your Honor. May it please the court, Ben Chu for Plaintiff Johnny Depp. It's just still morning. Your Honor, if I may approach.
All right. Thank you.
Thank you, Your Honor. I've just handed to Mr. Rottenborn and Your Honor an opposition that we prepared before we had the benefit of seeing Ms. Heard's affirmative motion to strike, but I think we've anticipated the arguments made, such as they are. The court should deny defendant Amber Heard's motion to strike because Mr. Depp has come forward in his case in chief with multiple credible witnesses, documents, and authentic tape recordings of Ms. Heard herself, not only satisfying all of the requisite elements of his claim for defamation, including actual malice, but also going the extra mile of showing that Ms. Heard physically abused him. She's the abuser in this courtroom. Your Honor, going back to the standard, as Your Honor is well aware, in considering a motion to strike, the trial court must view the evidence and all reasonable inferences drawn from the evidence in light most favorable to the plaintiff. Any reasonable doubt as to whether the plaintiff has produced sufficient evidence of the wrong alleged must be resolved in the plaintiff's favor and the motion to strike denied, unquote. And that's the Boeing case, I believe Mr. Rottenborn referred to, 243 Virginia 81 at 81, 1992. Quote, the weight and credibility of the testimony of witnesses are solely matters for the jury. The jury may accept that part of the testimony it believes and reject that which it does not. It is also within the exclusive province of the jury to draw any reasonable inferences from the evidence before it, citing Rate versus Minix, 275 Virginia 579 at 585. In deference and respect to the court's time, Mr. Depp incorporates by reference the legal analysis set forth in the court's opinion letter dated March 27, 2020, overruling Ms. Heard's demurrer to the 3 defamatory statements at issue. And that letter opinion is attached as Exhibit 1 to Mr. Depp's opposition. That's where the court fulfilled its proper gatekeeping role that Mr. Rottenborn referred to. As a threshold matter, the elements of a defamation claim are the following. Publication of an actionable statement with the requisite intent, citing the Shaker versus Bonfault case, 290 Virginia 81 at 91. As to damages, they are presumed here because Ms. Heard's false allegations of domestic abuse, sexual assault, and rape constitute defamation per se, citing the Tronfield case, 272 Virginia 709 713, a 2006 case. As the court noted at page 3 of its opinion letter, typically an editorial or op-ed column is ordinarily not actionable because it appears in a place devoted to or in a manner usually thought of as representing personal viewpoints. However, Virginia recognizes that, quote, a defamatory charge may be made by inference, implication, or insinuation, citing the Carwell case. And a statement expressing a defamatory meaning may not be apparent on its face, citing Pendleton, with which the court is quite familiar, 290 Virginia at 172. Accordingly, in order to render words defamatory and actionable, it is not necessary that the defamatory charge be in direct terms, but may be made indirectly, and it matters not how artful or disguised the modes in which the meaning is concealed, if it is in fact defamatory. Carwell, 196 Virginia at 7. And based on the authority and reasoning set forth in pages 4 through 8 of the opinion letter, the 3 statements at issue are actionable under a theory of defamation by implication. Mr. Depp established in his case in chief that Ms. Heard in fact made all 3 of the defamatory statements at issue. As the court admitted into evidence as Plaintiff's Exhibit 1, the op-ed Ms. Heard published in her own name in the Washington Post on December 18, 2018. And let's take the 3 statements and the proof that has been adduced. Statement number 1, Amber Heard, quote, I spoke up against sexual violence and faced our culture's wrath. That has to change. Per page 6 of the opinion letter, The first statement could reasonably convey the alleged defamatory meaning, i.e. that Mr. Depp abused Ms. Heard, to its readers without extending the words beyond their ordinary and common acceptation. See Pendleton 290, Virginia at 172, also citing the Carwell case. Resolving every fair inference in Mr. Depp's favor, this statement could reasonably imply that the sexual violence Ms. Heard spoke up against was in fact perpetrated by Mr. Depp. Mr. Depp produced several credible witnesses and documents proving that Ms. Heard was implying that he committed sexual violence against her. Mr. Depp himself testified to that, as did his sister, Christy Dombrowski. Mr. Depp's former agent, Christian Carino, testified that, as did his current agent, Jack Wiggum. But perhaps most convincing of all, and most disgusting of all, was the testimony of the ACLU's Terrence Doherty, a lawyer nonetheless. Mr. Doherty testified, among other things, that when when they were pitching the op-ed to the Washington Post, they stated, "Hey, Michael, wondering if we might interest you in a piece by Amber Heard, who, as you may recall, was beaten up during her brief marriage to Johnny Depp, on what the incoming Congress can do to help protect women in similar situations." Mr. Doherty also testified that everybody understood, as Ms. Heard and the ACLU clearly intended, that this statement and the other two statements referred directly to Mr. Depp. Quote, "This is an article that was in USA Today and specifically ties Amber's statement in her op-ed piece to Johnny Depp." And when Jessica Weitz, who actually wrote the op-ed that Ms. Heard later adopted, she says, quote, to Mr. Doherty, "So much for not mentioning JD," when the USA Today made clear that they, like everybody else who read the op-ed, understood that, as Ms. Heard clearly intended, it referred to Mr. Depp, which makes her Instagram post 2 days before the trial began, that she didn't mention Mr. Depp, all the more outrageous. Your Honor, there is Ms. Schulman, also of the ACLU, acknowledged that Ms. Heard's op-ed referred to Mr. Depp. So it's very clear that the ACLU and Ms. Heard intended, that was the whole purpose of this, so that they could get interest in this and it would coincide with the premiere of Aquaman, because otherwise no one would have been interested in anything written by Ms. Heard. Mr. Doherty also testified that Ms. Heard only paid 1.3, actually she didn't even pay all that, out of the $3.5 million that she had pledged to the ACLU, and then they helped her lie about it. And it's one thing, Your Honor, for her to stiff the ACLU, which frankly played a reprehensible role in this case. It's quite another for her to fail to honor her obligation to the Children's Hospital of Los Angeles with sick and dying children, and that she failed to do as well. And as Your Honor has mentioned, the fact that she put her name on that article means that she is responsible for all of those statements, which she specifically adopted later. And I'll go through the other two statements quickly, Your Honor.
Well, can we stay on this one for one moment, though?
Yes, Your Honor.
Because do you agree that the only evidence before that we've heard in this trial, as far as the title of the op-ed, is that even Mr. Doherty, I believe, testified to it, that it was something that Washington Post wrote?
Well,
for the one online.
He's not our witness, Your Honor. That's a witness from the ACLU.
Well, I understand, but it's the only evidence I have.
I respectfully disagree, Your Honor.
All right.
What the only real evidence Your Honor has is Plaintiff's Exhibit 1, which is Amber Heard putting her name on the entire article, including the title. That is the only evidence before you. The ACLU was a co-conspirator with Ms. Heard, and whether they say, oh, maybe the Washington Post wrote it, that's not the end of the story. All she has done is create an issue of fact as to whether she wrote the title or not.
So you're saying just having that exhibit in evidence is enough?
Absolutely, Your Honor. Her name is on the article. Okay. What does an average reader expect? So that alone is sufficient to beat a motion to strike. If they want to come back later and say, gee, she didn't write the title, as if that were a defense. I hope they make that argument. I hope they make that argument to the jury, because it's about as credible as her argument that, oh, I wasn't referring to Johnny Depp. She didn't have to. And the testimony of Terrence Doherty was very clear that when they took out the references to Johnny Depp, no one was interested in this article anymore. So she said, put it back in, make it more spicy so people would read. Otherwise, she couldn't get it in the Washington Post. It would be back in Teenage Vogue, which is the other publication that was considering publishing it, because no one was interested in what she had to say unless she was defaming Mr. Depp. But if I could go to the second statement, I'll try to be quick, Your Honor. 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. As for the second statement, defendant called herself a public figure representing domestic abuse, which can be read to imply that she became a representative of domestic abuse because she was abused by Mr. Depp, not just because she spoke out against alleged abuse. This inference can be drawn without extending the language beyond its ordinary common acceptation, citing Carlisle 196, Virginia at 8. Your Honor, quote, to constitute a publication, it is not necessary that the contents of the writing should be made known to the public generally. It is enough, it is said, if they are made known to a single person, unquote, citing Snyder versus Fatherly, 158, Virginia, 335 at 350. Everybody and his grandmother testified that Ms. Heard was referring to her bogus ex-parte TRO that she obtained on May 27, 2016. And it was interesting that Mr. Depp's own lawyer said that she wasn't even provided notice. So Ms. Heard made very sure that Mr. Depp wouldn't have notice of the ex-parte TRO. And Ms. Heard herself, the evidence shows, knew that Mr. Depp, having just suffered the loss of his mother, was already on the other side of the country, was already in New York at the time of this TRO, and was heading to Europe for several weeks. So she knew she didn't need any protection from him. This was just a scam for her to get the $7 million in the divorce settlement that she said she gave to the ACLU. She swore she gave to the ACLU and the Children's Hospital of Los Angeles, and she pocketed instead. Mr. Depp, Ms. Dombrowski, Mr. Carino, Mr. Wiggum, and the inimitable Mr. Doherty of the ACLU, which lent its once respected name to Ms. Heard's defamation. So while Ms. Heard may have avoided any direct mention of Mr. Depp's name, there is extensive testimony and evidence in the record showing that the implication of her op-ed could not be more clear, i.e., that Mr. Depp abused Ms. Heard during the course of their marriage. Under Virginia law, quote, it is not necessary that the defamatory charge be in direct terms, but it may be made indirectly. And it matters not how artful or disguised the modes in which the meaning is concealed if it is in fact defamatory. Citing Carlisle, well, we can argue as to how artful it was, but the implication was very clear, as the court has previously ruled, or not law of the case, but as the court has persuasively written in its opinion letter. Let's move to the falsity of Ms. Heard's ever-evolving and ever-escalating change of IPV and sexual assault. Mr. Depp's sworn denial is all he needs to survive a motion to strike, but there's a lot more than that, Your Honor, and I'll try to be brief. 3 police officers, actually 4, but the 3 who testified already, Officers Sines, Haddon, and Gatlin, testified unequivocally that Ms. Heard did not have a mark on her on the evening of May 21, 2016. And I could go through, I'll just go through very quickly. Officer Haddon, strike that, Officer Melissa Sines on jury trial day 10. Question, did you provide a copy of this pamphlet to Amber Heard? Answer, I did not. I didn't identify her as a victim of domestic abuse. The next day, Officer Melissa Sines. Okay, at this time, did you notice any injuries on Ms. Heard? Officer Sines, I did not. Question, okay, were you looking to see if she had any injuries on her at the time? Officer Sines, yes, I was. Question, and so you were looking to see if Ms. Heard had any injuries and you determined that she did not. Is that accurate? Officer Science, correct. Question, okay. And was the lighting good enough in the hallway for you to make that determination? Answer, yes, the hallway was well lit. Officer Gatlin's testimony was the same, and he had the body cam. Officer Haddon's testimony was the same. The testimony of nurses Debbie Lloyd and Erin Borem, who, like the police officers, did not work for Mr. Depp. In fact, they worked for Dr. Kipper, also belied Ms. Heard's false allegations of abuse. Isaac Baruch and Alejandro Romero both testified that they saw Ms. Heard repeatedly and in the clear light between May 21, 2021, which was the last time Mr. Depp saw her before leaving on the Hollywood Vampires tour. The next time he was to see her was when Ms. Heard begged him to come see her in San Francisco, which is hardly the act of a domestic abuse victim. So we have Isaac Baruch and Mr. Romero saying that they saw Ms. Heard repeatedly in the interval of time between May 21 and May 27th, when she obtained the farce ex parte TRO. And they saw no marks on her face and no swelling. Two witnesses, Mr. Baruch and Brandon Patterson, saw the video of Ms. Heard and her sister Whitney pantomiming the fake punch after this alleged incident of abuse. Ms. Heard's former personal assistant, Kate James, and several other witnesses, including Dr. David Kipper, saw no violence by Mr. Depp and no injuries to Ms. Heard. Indeed, witness after witness has come forward to testify that Ms. Heard, far from being a domestic figure representing domestic violence, unquote, is in fact a recidivist perpetrator of domestic violence on Mr. Depp and others. We have the testimony, the harrowing testimony of Mr. Depp himself, who described several witnesses. One, as Your Honor will recall, when he was hiding in the bathroom after escaping one of her attacks, and she claims to have hurt her foot kicking the door. Mr. Depp opens the door to see if she's hurt, and then she kicks the door in on him and punches him. We have the incident of December 15, 2015, when Ms. Heard threw punches at him wildly at the back and side of his head. Mr. Depp testified that he ducked and covered to protect his face. Eventually, he turned around to grab her and stop her arms from flailing. December 15 in the Bahamas, during an argument, Ms. Heard grabbed a can of mineral spirits and threw it at Mr. Depp's face, striking him in the forehead, bridge, and nose area, and the jury saw a photograph of the bridge on the bruise of his nose. We have testimony from Mr. And by the way, Tara Roberts, who is the manager of the island, confirmed that the incident with the mineral spirits. You have Mr. Depp's testimony of what happened on April 22nd, 2016. And we've heard testimony today from Erin Borem-Filati that Mr. Depp was very responsive, was very sociable, was not in any way inebriated that day when Ms. Heard says he was, and she attacked him that night as well. And I'm getting to the end of this, Your Honor. We have Ms. Heard's own admissions. We have her admitting to hitting Mr. Depp, and her only contention was that she wasn't punching him, she was just hitting him. We have testimony from Travis McGivern that on February 23rd, 2015, Ms. Heard threw and hit Mr. Depp with a can of Red Bull and then sucker punched him with a closed fist. Finally, we have the rather stunning testimony of Ben King, quite a credible witness who accompanied Ms. Heard on the flight back from Australia, where Ms. Heard admits to him in a rhetorical question, quote, "Did you ever totally lose it on someone you love?" Which was, we would respectfully submit, an admission of her severing the top or the tip of Mr. Depp's finger. Finally, Your Honor, statement number 3, quote, "I had the rare vantage point of seeing in real time how institutions protect men accused of abuse." Again, quoting very briefly from page 7 of the court's opinion letter, quote, "Drawing every fair inference in plaintiff's favor, the court can fairly conclude that defendant's statement that she saw how institutions protect men accused of abuse could reasonably convey to its recipients that she saw how Mr. Depp was protected by institutions, that he abused her and spoke up against it." Your Honor, again, we have multiple testimony from multiple people, including Jack Wiggum and all the others mentioned, that this was a reference to that. Your Honor, again, the lies that have already been exposed that Ms. Heard has told about the charitable contributions, the incidents in this case, and again, I'll just cite a couple of more, the testimony of Isaac Baruch. When Mr. Baruch saw Ms. Heard on June 3, after she'd gone through with the sham ex-party TRO, and Mr. Baruch was asked, did she say anything in response? And Mr. Baruch testified, yeah. In response to that, she, meaning Ms. Heard, looks at me and said, "I told Johnny I don't want anything. The lawyers are making me do all of this." And that's what she said. Well, the lawyers are making her do all of that. And apparently she wanted the $7 million for herself. She even lied about the final insult left on the marital bed after her 30th birthday party. And it was quite telling that she admitted to Starling Jenkins, a former United States Marine, that this was a terrible prank gone awry. Well, she lied about that too. In fact, she said Mr. Depp was crazy to even allege that she could have done such a thing. Well, she admitted it to Mr. Jenkins. Per Tronfield, as cited earlier, Mr. Depp does not have to prove damages because this is defamation per se. In fact, these involve some of the most heinous crimes any man or woman can be accused of. However, he has done so. Jack Wiggum tested yesterday that the impact of the op-ed was catastrophic on Mr. Depp's personal and professional life, that it was a $22.5 million loss on Pirate 6 and another $20 million on others. We've had the testimony, so we had Mr. Wiggum testifying as to the 22.5 lost on Pirate 6 and another 20 lost on the other films, the other studio films, the indie films, and the other ways Mr. Depp would have made income. We have Richard Martz's testimony, Douglas Banya's testimony, and the testimony of Michael Spindler just this morning. Finally, Your Honor, none of Ms. Heard's affirmative defenses, which would include, her trying to create an issue of fact on the title, can support a motion to strike, as to which she bears the burden of proof of her affirmative defenses. Quote, "Whether the defendants have met their burden cannot be resolved when considering a motion to strike." See 243 Virginia at 83. And just to respond to Mr. Rottenborn's citation to the Lacova case, which we hadn't seen until he mentioned it today, I would only note, Your Honor, that defendant admits that she tweeted a link to the online version of the op-ed at paragraph 97 of her answer, though again, the admission of Exhibit 1 is more than enough to survive the motion to strike. And the Lacova case at 995 F3rd 134 holds that republishing a hyperlink doesn't necessarily start the statute of limitations, not that a hyperlink cannot be defamatory. So with that, Your Honor, we respectfully request that the court deny the motion to strike in full, and let's hear from Ms. Hurd. Thank you, Your Honor.
Yes, sir. Thank you. Your motion?
Thank you, Your Honor. I can only assume that Mr. Chu wrote that speech for an audience outside the court because it didn't really address my arguments. I'm going to focus on what our specific arguments are for the motion to strike, Your Honor. Mr. Chu spent almost 30 minutes of the court's time talking about the disputed evidence of physical abuse in this case, which Ms. Hurd hasn't even put on her case, and I can tell you she's not the abuser, and if the case moves forward, she and her witnesses will put on even more evidence of the physical abuse she suffered at the hands of Mr. Depp. But that's not the basis for our motion right now, Your Honor. He talks about how Mr. Depp had a sworn denial, and that should count. We read his testimony. He claims he didn't strike her. But again, that's not the basis for our motion. The basis for our motion is the clear and undisputed evidence of non-physical abuse. By his definitions, by his standards, by the standards of his expert, there is no dispute that Mr. Depp abused Amber. And therefore, if he did it even one time, there is no dispute that even under their theory of the case, the implication that they want the jury to draw from the article, which again, I'm not arguing for the purposes of today, because under the legal standard, I'm not going to argue that. I'm not going to waste the court's time with that. But even under their standard, the undisputed evidence is that Mr. Depp did commit abuse against Ms. Hurd, and therefore that those first two statements were false. That's our argument on that. As to the headline, it's funny, Mr. Chu, we played 2 or 3 hours of an ACLU deposition. Now he says, well, that wasn't our witness. It was his witness, Your Honor. He just spent 10 minutes talking about what Mr. Doherty said, and Mr. Doherty testified that the Washington Post wrote the headline. That is the only evidence, Your Honor. I understand he says, well, Exhibit 1 has her name on it. Exhibit 1 has her name on it. But the only evidence in this case about who wrote that headline is Mr. Doherty's testimony. It is undisputed. They could have put anyone else on. They could have called Ms. Hurd for that because that was not part of the stipulation at the pretrial conference. It was only the tweet that we talked about, Your Honor, and they chose not to do that. Now, Ms. Hurd will testify she didn't write that headline, so it wouldn't have helped them. But they've had 3 weeks to put on their case, Your Honor. They've controlled the playing field of evidence. There is no dispute that Ms. Hurd did not write that headline. No dispute. Simply saying, well, her name is attached to it, that can't overcome the testimony of the ACLU. They call them a co-conspirator. Of course, Mr. Depp chose not to sue them. But the testimony of Terrence Doherty that she didn't write that headline, that takes care of the sexual violence headline, Your Honor. And I'm not going to take up any more of the court's time addressing portions of Mr. Depp or Mr. Chu's argument that don't go to our motion, unless Your Honor has any specific questions. But I want to be respectful.
All right, thank you, sir. All right. For this motion, I've taken the arguments of counsel, and last night I reviewed all of the evidence that has been submitted in this matter. So as to the second and third alleged defamatory statements, at the motion to strike at this juncture, I view the evidence in the light most favorable to the plaintiff and reasonable inferences from the evidence to the plaintiff. And if there is a scintilla of evidence that a reasonable juror could weigh, then the matter survives a motion to strike. In this matter, there is evidence in the case that a jury could weigh that the statements were made by the defendant, that the statements were about the plaintiff, that the statement was published, that the statement is false, and the defendant made the statement knowing it to be false, or the defendant made it so recklessly as to amount to a willful disregard for the truth. The weight of that evidence is up to the fact finder. So the motion to strike is denied as to statement 2 and 3. The motion to strike as to statement 1, I'm going to take under advisement because if it's not a stipulation, I'm not sure what it is, but there seems to be an agreement that the tweet of Ms. Hurd is part of the plaintiff's evidence, which is not in evidence at this point. So I can't rule on that statement whether or not it is just a tweet or if it's some sort of republication or something. I don't know because I haven't seen it yet. So as to the motion to strike on statement 1, I'm going to take under advisement because ruling on it now, it would be premature because I just don't have that evidence in the case, okay?
Thank you very much, Your Honor.
All right. Since it's 12:30, you want to just take lunch? Go ahead and let the jurors go to lunch and come back at 1:30. Does that sound okay? Yes. Okay. All right. Do you want to do it now? Yes. Okay. Sure. All right. Anything further? 1:30. What time? Court's in recess in 1:30.
All right.